So for those who don't know, Lee is with the Santa Clara office, and I'm with the Edison office. We're going to be talking today about appeals and motions, and just to give you a little bit of an idea about the different kinds of options for appeals and motions in the immigration world. Mostly on the administrative side, which is with the agency itself. Depending on the kind of case matter, you would choose the office that has jurisdiction over the appeal or the motion. So when it comes to a decision of a judge in immigration court, you would go to the Board of Immigration Appeal, the BIA. And so the majority of appeals reaching the BIA involve orders of removal and applications for relief from removal, certain kind of family-based immigration matters. The next one is the OCAHO, which is the Office of the Chief Administrative Hearing Officer. And the OCAHO oversees proceedings on unfair immigration-related employment practices, labor practices, employer sanctions, etc. So mostly relating to regulations of the Department of Labor. So that's another kind of appellate office. Then you have the AAO, the Administrative Appeals Office, and that's really the office that we deal a lot with for our type of cases, the employment-based cases. So the AAO is the appellate body that reviews the majority of decisions made by the service centers. And when you have a denial on a case, on a petition, on an I-21, I-29, or an I-140 petition, this is the agency that you would go to. There's also the BALCA, which is the Board of Alien Labor Certification Appeals, which reviews denials of labor certifications. So these, are mostly the type of appeals that you file on the administrative side. Then, of course, you have the federal court option. And this is a different animal altogether. The important thing to note is that you don't have to exhaust administrative remedies first. You can choose to directly go to federal court. And as many of you know, more and more immigration matters, even on the employment side, are getting litigated these days. And many of the changes in the regulations have been brought about by federal litigation. Okay, so that's in brief, a snapshot of the different types of appellate options. All right, so on to Lee next, and she's going to talk more in detail about motions and appeals.
Mostly we deal with USCIS denials. So today's seminar, we focused on talking about USCIS motions and appeals. And when you file a motion and appeal, when you receive an unfavorable decision issued by the USCIS, and there are three options: motion to reopen, motion to reconsider, and or appeal. So first we talk about the motion to reopen. Motion to reopen is a request to the office which issued the unfavorable decision to review its decision based on the new fact. The new fact means the fact that you have not submitted previously in the initial filing, and you are submitting some new fact which were not available at the initial filing. And if you just submit the previously you submitted evidence, the office will not consider about it. Also, these new facts must be supported by the affidavits or other documentary evidence showing that your eligibility at the time of you file the underlying application or petition, not at the time you file the motion. And also, of course, the new fact must be relevant to the issues of the motion. And if you field filing a response to a RFE or a notice of intent to denial, you can file a motion to reopen if you can show that the requested evidence was not material, or the required initial evidence was submitted with application or petition, or the request of the appearance or additional evidence was complied with during the allocated period, or the request for evidence were not sent to the address of record. However, in reality, the D is not very easy to overcome. If they have a record, if the USCIS record showing that they already sent the RFE or notice of intent to denial to the address on their record. Motion to reconsider is a request to the office that issued the unfavorable decision to review its decision based on an incorrect application of law or policy. So motion to reconsider, in the motion to reconsider, you must prove that the decision was incorrect based on the law and with the evidence you already submitted in the initial filing. Because unlike a motion to reopen, the USCIS will not consider new fact or evidence in a motion to reconsider. You just need to explain why the application of the law by the USCIS is incorrect, and you need to cite the appropriate statute, regulations, or precedent decisions, and to establish that the decision was based on an incorrect application of law or policy. So the office need to approve your case. Now we come to AAO Appeal. AAO, as Diya said, it's an administrative appeals office in the USCIS. They conduct appellate review of immigration benefit request within its jurisdiction. It's not like all the cases can be appealed by AAO. It has a jurisdiction almost around 50 different immigration cases types. What we usually see is I-140, I-129, most employment-based immigrants and non-immigrant visa petitions. This is what we usually file. And others like EB-5 related, the Form 526 and also Regional Center application, I-924. And the third is temporary protected status application. And four is a fiancé petitions. 5 is waiver applications, and 6 is application for permission to reapply for admission after removal. And you can see 7, 8, 9, 10, 11, 12. These are all the petitions and applications which you can file appeal with the AAO. These cases, and this is a place that you can file appeal with AAO if you receive an unfavorable decision. And I put a website here. This is you can use this website to check whether your case you can file a motion or you can file appeal, or you can choose both to file the motion and appeal, because some cases you can file motion but you cannot file appeal. Diya may talk about it later. Other issues with the AAO appeal is that when you file appeal with the AAO, actually it will stay with the initial, it will be submitted to the field office where it denies your petition or application, and they will conduct the initial field office review. Usually, they treat it as a motion, and they will just they're supposed to give you a result, give you a decision in 45 days. They either approve the case or they think that they are correct, and then they send the case to AAO for further adjudication. And also the decision from the AAO, there are two kinds of them. One is precedent. It's like it binds on the service in all employees, and and for the future cases. And the other one is non-precedent. Non-precedent decisions only bind on the parties. However, the USCIS may adopt these non-precedent decisions and use it in their policy and ask the USCIS employee to apply them in their practice. And currently, I just checked, and currently there are 20 adopted non-precedent cases only. Yeah. And the standard of review by AAO is a de novo. It's a de novo review. De novo review, it means that it's a new review without it's a dependent. The AAO is independent of the field office, And they do on appeal, they look at the record anew, and their decision may address new issue that was not raised or resolved in the prior decision. And the burden of the proof, of course, is appellant. The appellant has a burden of proof to establish eligibility for the request benefit. The burden of proof actually include two sides. One is the burden of production, and the second is the burden of possession. Burden of production is that you must submit enough evidence, and the burden of possession is that you have the obligation to persuade the agency that the final decision should be favorable to the appellant. Basically, it's like a bar examination. You need to connect your fact with the rules, and also, persuade the officer to approve and explain why they are related, and persuade the officer to approve your case. And the standard of proof. Standard of proof is you must prove that they need this a preponderance of the evidence. Instead, in another way, is that the appellant must establish that there's a greater than 50% chance that a claim is true, then the AAO will approve your case. So sounds not bad. However, in reality, actually, it's very strict. I don't think if you, if your case looks like a 50% true, they will approve your case. At least you need to have around like 80% or even higher. And supporting evidence. So supporting evidence, it's like you submit new evidence, it's okay. With the AAO, you submit new evidence, that's fine. But you must be eligible for the required immigration benefit at the time of filing and remain eligible through the adjudication process. So, for example, if you have an equivalent degree and you use education and experience to reach equivalency, and at the time of filing, your beneficiary need to be qualified for this one. You cannot use the experience after your initial filing to get equivalency, related equivalency at the AAO stage. That doesn't work because you need to prove that he's qualified for this position at the time of initial filing, not at the time when you file the appeal. AAO decisions, there are 5 types of AAO decisions. First is sustain. Sustain basically is like approval. They sustain the appeal and order the approval of the application of the petition directly. And the second is dismissal. Dismissal is like a denial when the applicant fails to establish the eligibility of the request benefit, and when it is moot, appeal is moot. For example, it turned out that the appellant already get the benefit through other means. There's no meaning to process this appeal further. Or when the appellant withdraw the appeal or fails to respond to RFE or notice of intent to denial timely. This one, if you get a dismissal from the AAO, you can file a motion to reopen or reconsider, if they deny your case, basically. Summary dismissal. Summary dismissal is like when an appeal does not specifically identify any legal or factual error in the original decision, and the AAO don't think that it's worth of processing the case further. They just issue a summary dismissal. Reject is like when it happens when the applicant improperly file an appeal, And remand is a decision that the AAO issued to the office that made this unfavorable decision to take further action or to enter a new decision. So when you see remand, it's a good sign, but it's not a guarantee that the field office will approve your case. otherwise the AAO will just sustain the case. The AAO found that there are some fact or issues. The field service may apply wrong. However, there are other facts and issues which support the field office denial decision. That is why they want the field office to review it again and make a new decision accordingly. So in the remand cases, you may receive a final decision from the field office with approval or with another denial. So these are the decisions issued by AAO. And also the decision, AAO appeal decision, is effective and final on the date that the AAO issues it, on the mailing date, unless the AAO reopen or reconsider, unless you file reopen reconsider the decision on the as Diya said, you file it with the federal court, and the federal court order this AAO to reconsider or just approve the case.
So I'll talk a little bit more about the procedural requirements with the motions and appeals. So Lee already talked to you about when to title the filing as a motion and when it should be titled an appeal. In terms of timelines, pretty much all motions and appeals should be filed within 30 days of the adverse decision. The mailbox rule allows us to add about 3 more days, and they are very strict about this. Where to file? The filing location changes from time to time, but for I think the past few years, USCIS has been asking us to file most of the filings go to the lockbox location. I think it's a Phoenix lockbox. And with the lockbox, what happens is that they take the case and then they will, forward it to the appropriate center. So if it's an appeal, then they'll forward it to the AAO, I guess, once they have done the field review. And if it's a motion, then they will send it to the service center, which had original jurisdiction over the case. You have to file it with the form 290B. That's the motion or the appeal form. It's a fairly straightforward form. I think it's only about 4 or 5 pages, but you do have to enter the details correctly, like the date of the denial, the receipt number. The correct fee amount has to be enclosed. If you get any of those wrong, like the filing location, the complete forms, the signatures, or the fee amount, if any of those are incorrect, then the package will probably come back, and it will not be considered to be filed. You should also include some supporting documents, the most important being the brief, right? And the brief is, as Lee also mentioned before, that is a statement where you explain why you think the case should be reversed, or whatever relief that you want. You explain why you think the service center made a mistake, either in fact or in law, or if you have new evidence. If you're filing it as an appeal to the AAO, in that case, the brief may be submitted within the next 30 days. But with motions, you have to submit everything together. There are also no specific formatting rules relating to the brief. So I think that's a common misconception. People think that you have to follow the federal code formatting rules. When I first started out, I would have all these templates, which were like an official court complaint. But that's really not the case. You can, pretty much use any format. I think what matters is you explain clearly why you're asking for the decision to be overturned. It's up, depending on the type of matter, you might want to resubmit documents. So if it's an appeal and if there is no new evidence that you're entering in the record, you don't have to resubmit any of the documents. So, whenever I submit an appeal, my supporting document is really just the brief. I don't resubmit any of the exhibits. I just reference them as they were part of the record, right? Either with the initial filing or with the RFE response. If you entered them in the record, you can just point to that. And I think it's easier to persuade the AAO that the service center has been unreasonable if you can point out that these documents were already submitted. So that's generally what I do. But I know that other practitioners, they like to resubmit some of the more relevant or the more probative documents. So it's up to you. As Lee mentioned before, the AAO has the power to take new evidence into consideration. So if you have something that is important, which you think gives additional weight to the case, then you can always submit it anew. Also, this is something that I realized when I was researching a little bit for the presentation today. Apparently, the AAO has the discretion to extend the deadline for submitting a brief if there is a good cause that you can show. But I would think that those are rarely given and probably only for very compelling situations. And given the timelines that we are seeing, even in terms of getting a receipt, I would not try this at home. Okay. The AAO can also ask for more evidence. So this doesn't usually happen, but I think I've had one or two cases where the AAO actually asks for more evidence, and I guess this is a good sign because it means that at least they're not going to deny the case. They're looking at more information. The case that I recall most is we had this I-140 beneficiary, and the I-140 petition was denied because USCIS said that he didn't have the equivalent. He didn't have the equivalent of a bachelor's degree from India. But we were able to get some proof that the university that he went to had, had sufficient accreditation from UGC, which is the commission that oversees universities and schools in India. So we had that, and we went to the AAO, and then the AAO sent an RFE asking for additional information. They wanted the university to send some documents directly to them in the original. And of course, they gave us only 30 days for that. Somehow we made it work, and the case was approved. So just to point out that they also have the authority they have the power to ask for more documentation if needed. Who may file the appeal? This, as all practitioners know, this is a question of legal standing. So only the petitioner and not the beneficiary can file the appeal or the motion when it comes to I-140s and the H-1Bs. So if the employer is not willing to cooperate, then there's not much that the beneficiary can do when there is an adverse decision. Processing times for an appeal. For a motion, I think it's actually, we'll talk about motions first. It's been a long time since I've filed a motion. So with the motion, you only get one shot, right? It only goes to the service center. I used to do that in the past for cases where I thought there was an egregious or very clear mistake. For example, a case where a mechanical engineering position was denied for specialty occupation reasons, and then we were able to, that's obviously a clear mistake, because to be a mechanical engineer, you have to have a mechanical engineering degree, and the OH and everything is very clear on that. So with that, with those type of situations, we would file motions. But with the AAO, the estimated timeline now is about 180 days. That's their goal. That's the timeline that they have given themselves. But I think, honestly, it's very rare that they meet that goal. Most cases now are actually taking more than 6 months, even with the AAO. So I pulled out some, statistics. The AAO from time to time will actually publish their performance data, right? And it seems that they're well behind. So for employment-based categories like H-1Bs and I-140s, I think less than 50% of their cases are actually getting adjudicated within the 6 months. Just briefly about amicus curiae. It's a Latin term. It means, friend of the court. But when there is a novel question of law or policy, the AAO can invite, other members of the public to comment on it or, give their perspective. So an amicus brief is a written statement from a person or an organization that is not a party in the case, but has a strong interest in the issue being considered. And again, this is something that I didn't know before, but apparently the AAO from time to time will publish on their website when they're when they're soliciting these briefs. So I checked the AAO website, and it seems the last time that they posted such an invite was in 2016. And the issue in that matter was again, going back to this whole question of legal standing, the issue that they were considering is whether the beneficiary, as a stakeholder, can file the appeal when it comes to I-140s and H-1Bs. I'll also talk about a few other factors to consider. Untimely filings. So an untimely file. So remember we spoke about the 30-day deadline, the 30 plus 3 days for filings. So with an appeal, they will certainly not entertain the filing if it is beyond the 33 days, right? But the rule is that if an untimely appeal meets the requirements of a motion to reopen, they are supposed to treat it as a motion and consider the case on merits. So if you're not able to file the appeal in time within 33 days, then and you still want to go ahead, then you're probably better off filing it as a motion, and maybe just in the brief or somewhere just add a note that it is outside the statutory period, but you would like for it to be considered on the merits as a motion. The other question that comes up is whether it makes sense to refile or to file a motion or an appeal. If you file a second petition on the same issue, and you can certainly do that while the case is on appeal to the AAO, but what will happen is that if the service center knows, or if they figure out that you filed an appeal on the same issue, they will hold the case. They will hold the second petition until the appeal is adjudicated. So you might not really, gain anything by the second filing if you, in parallel, if you file the appeal. Unlawful presence. So an appeal to the AAO will not toll unlawful presence, which means that if the, thank you. Thanks, everyone. Have a good day.